Hello, my name is Richard Felton and I'm a partner in the firm of Gordon Edelstein Krepek. I'm also a certified specialist by the State Bar of California in the field of workers' compensation. We represent injured workers in California workers' compensation cases, both for employees employed in the public sector and the private sectors. Today, I want to talk to you about the first 90 days after an injury. Note, there are exceptions in the labor code to what I'm going to talk about the time limits for COVID cases. So that's a separate topic, and this does not apply, or the laws I advise you regarding do not apply to COVID cases. When an employer knows, should have known, or is requested by the employee to provide a claim form is to be provided to the employee, to file with the employer. It is important that if you are filing a claim form, all the body parts you feel are injured are included in that claim form. Once a claim form is filed, the employer has basically 90 days to either accept or deny the case. They are within 14 days to advise whether they accept it or wish investigation, and again, they then have 90 days to decide whether they wish to accept the case or not. During that 90 days, the employer is to offer and provide medical treatment and pay for it up till either the denial of the claim or till payment of up to $10,000. Unfortunately, in our experience, this doesn't always happen. So rather than waiting around to have your employer send you to a doctor, if they're not doing it, you should continue or go to a doctor on your own, advise that the injury has been denied at least at this point, and try to obtain treatment with your group insurance, hopefully if you have it. Okay. Also during this time, the employer is not, unfortunately, required to provide temporary disability until they accept the case. So if it's not accepted, they're not going to pay it, and it's very important that the injured worker at that time apply for state disability, which is a backup for payment in the event that workers' compensation does not pay. State disability is only for workers who pay into the system, so if not, like many public employees, hopefully there'll be sick leave to cover the time until the injury is accepted. Okay? It's very important to note that workers' comp injuries can include any illness or injury that is caused or aggravated by work, internal injuries, psychiatric injuries, orthopedic injuries, any illness or injury that is caused or aggravated by work. If the injury is denied, the employee then has the right to file an application with the Workers' Compensation Appeals Board to attempt to prove industrial injury. If the injury is not denied within 90 days, then the injury is presumed compensable. Such a presumption means it is easier for the employer to prove injury, as it becomes the employer's duty to prove they weren't injured rather than the usual burden of proof on the employee to prove injury. Again, if an injury is denied, you are entitled to a hearing before the Workers' Compensation Appeals Board, and we strongly recommend early in the scenario here that you consult with an attorney. Quite frankly, anytime there's a significant injury, we recommend at least a consultation with an attorney. If you have any further questions about this topic or any other issues concerning a workers' compensation or personal injury matter, please feel free to call us at 213-739-7000 or contact us at www.geklaw.com. Thank you.